Scott, since there are statutory damages, are they being covered under the policies?
They should be, unless the policy says they shouldn't. And that was one of the issues. That's how it works, folks. But that was one of the issues in the Hartford versus Crate and Barrel case, where Hartford, according to the news stories, had agreed that the common law claim should be defended. And there was a question about the statute, because what had happened was, you've seen this in the back of GL policies, where you'll see at the very end there is the blast facts exclusion. And now, smarter underwriters are starting to expand that beyond just blast facts. Where it started, I was really limited. It would say the letters of the statute, and it would be very specific, and it would say in any state law similar to that. Now, the exclusion is being changed. Sometimes it's being lengthened to say other types of claims of a similar nature or any other communications, and sometimes it's being shortened where it's very brief and it's extremely broad. And so if you have that in your policy, which likely was in the Hartford's Crate and Barrel insurance policy or policies, then you have more of an uphill battle if it's only a statutory cause of action. So I'm not telling any plaintiffs' lawyers how to plead their next class action, but I am saying if that you see there's a common law claim in there, in addition to the statutory ones, then you know that you have an argument around the blast facts or the broadened blast facts exclusion for statutory causes of action at a minimum. And you know, I know that I said it's somewhat in jest in terms of if it's not excluded within the policy, it's covered. That is the basic starting point for how you figure out whether you get coverage for, particularly a defense, for a claim. If it's within the basic insuring agreement, for GL, if it's within bodily injury or there's allegation of property damage or allegation of personal and advertising injury, or if you look at your E&O policy and there's an error, omission, or however else that coverage is defined, now you're starting from a position where there should be a duty to defend unless there is an exclusion that absolutely knocks out everything. And so scour these complaints carefully. And if you see that there are allegations of both statutory and common law, you might be able to argue that there is a duty to defend. If you see only statutory violations alleged, you may still be okay if it's not within the exclusion in particular, or if you're in a state in which the coverage law says that it is the nature of the conduct that controls rather than the actual cause of action that controls. And there are a lot of states that say this. California is one of them. Florida says the same thing, and that they say tort law and insurance law and liability law do not intersect and are not coterminous. So that if the cause of action sounds similar to what's in the insurance policy, but is not exactly the same or has a different standard or different burden of proof, you nonetheless should be able to get a duty to defend.